I'm Jim Tomkovitz, and I have taught at the University of Iowa College of Law for the past 30 years, and I'm the author of Criminal Procedure, Constitutional Constraints Upon Investigation and Proof. The book focuses on the traditional subjects in a criminal procedure course, a first criminal procedure course, on the Fourth, Fifth, and Sixth Amendments, which is search and seizure law, the constraints on police efforts to obtain and use confessions in the courtroom, which are both the Fifth Amendment and the Sixth Amendment, identification processes, that is, efforts to obtain eyewitness identifications of suspects, and there's two constraints there, both the 14th Amendment due process clause and the Sixth Amendment right to counsel. And then finally considers the exclusionary rules, which are all of the different doctrines which keep evidence obtained illegally from being used in the courtroom. Through the first 6 editions, it has evolved slowly as new Supreme Court cases have come out. We've added them, we've had to make room, so we've either reduced or eliminated prior opinions. In every edition, new problems have been added, but to prevent growth, some of the older ones have been taken out. This newest edition coming out is actually going to be the most significant evolution in the 20 to 30 years that the book has been around. 3 of the chapters are going to be reorganized, 2 of them involving confessions, and the last chapter involving the exclusionary rule. So it's going to be some significant reorganization in a couple of the chapters. The first one would be that it's susceptible to use by at least 2 very dramatically different teaching methods. The first is the traditional focus on the Supreme Court opinions, teaching those, analyzing those, and then perhaps going to the problems to apply them. But the book has a full array of problems for each chapter, and in many chapters for each subsection. And that allows it to be used for those who prefer the problem method, which is a more practically oriented method in which you focus the students on the problems, assuming they've read the cases, and bring out the doctrines and use the actual problems themselves to develop the understanding of the doctrines, to highlight where there are unanswered questions, and to allow the students to make arguments about how the opinions in the preceding chapter could be used to dictate an answer one way or the other, or perhaps ambiguously in either direction. And so the problems can be the focus of a teacher's attention in each of the chapters. Each edition has had a very ample teacher's manual that first analyzes the Supreme Court opinions and then deals with the problems. Each of the problems is based on an actual opinion from the Supreme Court, but more typically lower federal courts or the state Supreme Courts or state appellate courts. And those problems have full analysis in the teaching manual. That is, not only are they described, are the facts described and the resolution by the lower court, but we can include our own analysis of how the problems might be argued and how they might be resolved. There's a plan that's developing to use the coursebook support community that Lexis provides and hopefully develop a forum using the discussion boards for the adopters of the casebook to go online and discuss the merits of the problems and actually debate them among themselves and hopefully enhance the learning and take that into the classroom. Well, the book includes enough material to fill an entire four-hour course for the semester. But there are chapters I have found myself that are certainly dispensable, that are optional. And I think an instructor has to make choices. I'm certainly willing to work with instructors who contact me, but instructors have to make choices about the cases that are most important and the focus that's the most important. I have told others that, for example, the identification material, there's 2 very short chapters toward the end of the casebook, and those opinions in those chapters actually were handed down by the Supreme Court over a 10-year period, and they haven't been interested in the subjects since the late 1970s. Consequently, I think as a practical matter, those chapters, while fascinating and somewhat useful, are the least useful. And so in having to make choices about what to cover in curricula that have different hours allocated to this course, I would choose to omit those chapters or to truncate coverage of those chapters dramatically. So it's very flexible in terms of having segregable material that can be used or not used. It's a long way to think back. It was the early 1980s, and I had been in teaching for a relatively short time. But I was dissatisfied with the book I was using and with others in the field. And at that time, the publisher put me in touch with Welsh White, who was my co-author for a number of years before passing away. Welsh and I agreed that the casebooks that were available did not allow ample discussion of the important Supreme Court opinions because they tried to do too much. They tried to ask too many questions and cover too much in the casebooks. It was our decision to do something quite different, and that was to provide more of the opinions and more of the dissents that would allow the students to really see the reasoning and appreciate the reasoning in depth, so that they could actually debate the issues and actually use the cases in new situations, which leads me to the problems. The other reason was to provide this practical, flexible teaching tool where the problems could be supplemental or they could be an alternative focus of the teaching. And I don't think that the rationale has changed at all through the 7 editions. I think it still has the same force. When I look at the other case books and the competitors, I really strongly prefer the styles of teaching and the depth of appreciation that can be fostered by using our casebook.